Okay. All right. So why don't we get started? So welcome everyone to our November Psychology Grand Rounds. We are very fortunate to have speaking today Professor Michael Ambrosio. He's going to be, presenting a really just interesting talk on ethics. We were just chatting about just how complex ethics is and, many perspectives, many ways to think of it. And so, Professor Ambrosio, thank you so much for giving this talk. Just for a little bit of a background, Professor Ambrosio is a professor of law at Seton Hall Law School. He currently teaches professional ethics and legal philosophy. During his more than 40 years of law school teaching, he has taught numerous subjects, including contracts, business associations, equity torts, trial practice and remedies, and he's founder and first director of the Seton Hall Law School Clinical Program. He was director of the Seton Hall Law School Law in Italy program and was a visiting professor at the University of Parma and the University of Florence, both in Italy. In almost 50 years as a lawyer, he has represented lawyers and law firms as an ethics consultant on a regular, almost daily basis, and as an attorney or expert witness in more than 400 cases involving legal malpractice, attorney discipline, or attorney disqualification. He has argued many cases before the New Jersey Supreme Court. Professor Ambrosio has served on numerous committees of the New Jersey State Bar and was reporter and vice chair of the New Jersey Bar Committee to evaluate the proposed ABA model rules of professional conduct. He has served on the New Jersey Supreme Court's, I'm going to misstate this, the Debevoise Committee to evaluate and proposed ABA model rules and the Pollack Commission on the New Jersey Rules of Professional Conduct. He is the author of numerous articles on professional responsibility, legal malpractice, and legal ethics, and lectures frequently for the New Jersey ICLE and professional organizations. He is the recipient of the New Jersey's ICLE's Distinguished Service Award. Professor Ambrosio, very accomplished, received his bachelor degree from Montclair State University and his law degree from Catholic University of America. He lives in New York City with his wife, Janice Gordon, who is an artist. So really very qualified, very much looking forward to hearing, your talk today, Professor Ambrosio. For those who are seeking CE credits, that link will be posted to the chat midway through the talk, so just look out for that. Professor Ambrosio, the floor is all yours.
Well, thank you very much, Christina. This talk will be in a few different parts. The first part, I'm going to talk about my encounter with the subject of professional responsibility and legal philosophy, particularly the subject of law and morality. The second part, I'm going to talk about the American Psychological Association's principles and standard of conduct applicable to psychologists, and review practically some of the provisions that I consider to be problematic or most important. And then I'll turn from a practical consideration of professional ethics to a broader question of theories of moral reasoning, the different categories of ethics, and particularly normative ethics and the different approaches to moral reasoning that's included in that heading of normative ethics. And ultimately, I want to conclude with some reference to John Finnis's contemporary natural law philosophy in natural law principles, which are not readily referred to, but it's a minority position, but I think it's worth having some consideration of the soundness of those ethical principles. So to begin with, I remembered the 1970s, I guess it's 55 years ago. First faculty meeting, I was 27 years old, and I was just appointed to the faculty of law school. And the first faculty meeting was 2 weeks into September. And at the meeting, there was a motion to abolish the course in professional responsibility and to take the course in legal philosophy, which was a required course, and make it an elective course. And the reason given by the proponents of this motion was you can't teach ethics. And students come to the law school already having formed their ethical views, ethical stance. And with regard to jurisprudence, the average student was too difficult for the average student. So sitting there somewhat amazed that the two courses that I consider to be the most important part of a law school curriculum, especially in a Catholic law school, one was being abolished and the other was being limited to an elective course. So I proposed an amendment that students be required to take one or the other. This didn't make a lot of logical sense, but it was a way of signaling to the students the importance of both courses in the hopes that they would take both courses. At the end of the meeting, everybody came up to me and says, well, no one wants to teach this. You're going to have to teach these courses, which certainly was fine with me. As a new professor, I was open to teaching both these courses. And I began the next year to teach professional ethics, which was just before the Watergate scandal. And ultimately, I became pretty much an authority over the next 5 or 6 years, and turned that experience of teaching into a fairly lucrative practice as an ethical consultant. But with regard to the teaching of jurisprudence, legal philosophy, I didn't feel competent to do that. And I started a program of study after 14 years of study of the major works of philosophy, political, moral, and legal philosophy. I undertook to teach the jurisprudence course. But I would just like to talk about my experience with John Finnis's natural law. I didn't understand. Is there some problem with the?
Can everyone please mute themselves? Okay, I think everyone is muted.
Okay. Well, I was in 1984. I was heading off to Italy as a visiting scholar at the University of Florence, and I stopped by way of Oxford University to attend a conference on values in education.
You've muted.
Hold on, I made a mistake. I need to change that. So hold on a second. Yeah, I muted you, so I want to unmute. So it's to unmute. Okay. Professor Ambrosio, you're muted. Can you unmute yourself?
Okay.
Yeah.
So I started to browse in this book, and it answered all the open questions I had about moral theory, and particularly natural law theory. And I spent 5 hours at the bookstore reading this book because it was impacting me so much. And ultimately, it was 9:30 when the bookstore was closing and I had to leave. But it had such an effect upon me that I immediately studied carefully what John Finnis has to say about this important subject of natural law. And of course, his natural law theory is it's a restatement of the classic Aristotle Aquinas Aristotelian Thomistic view of natural law. And I'll leave to the end of my talk the particulars of his theory and suggest why Finnis and his theory of natural law is perhaps a solution to the problem of how to teach ethics. So let me go back to the more practical question of how one deals with the code of the principles and the code of ethics of the American Psychological Association, which was promulgated in 2002. And I saw a certain parallel between the rules of professional conduct in New Jersey and the psychological the rules applicable to psychologists. One thing that is particularly significant, I think, is in both the model rules and the psychology ethics standards, there's a recognition of the limitation of the value of rules in ethical decision making. So the model code for lawyers says compliance with rules, as with all law in an open society, depends primarily on understanding and voluntary compliance. The rules do not, however, exhaust the moral and ethical consideration that should inform a lawyer. For no worthwhile human activity can be completely defined by legal rules. The rules simply provide a framework for the ethical practice of law. Now, the American Psychological Association promulgated this statement in its preamble to the standards of conduct. Ethical Principles of Psychologists and the Code of Conduct, published in 2002, provides that there are general principles that provide aspirational goals that are non-enforceable rules that should be considered when psychologists are arriving at ethical course of action. And these principles are beneficence and non-malfeasance, this notion of doing good and doing no harm, fidelity and responsibility, which includes fidelity to the client interest, loyalty to clients, fidelity to the truth, and responsible actions in the face of problems. Integrity, of course, honesty and sincerity in the process of decision making. Justice, and justice essentially is consistent with the very nature of human relationships, two forms of justice, distributive justice and commutative justice. Distributive justice becomes particularly problematic because it's perhaps the most violated proposition in our social decision making. Distributive justice says everyone should get a fair share of the resources. Now, it's interesting, Mondavi is arguing for a redistribution of the wealth. And so his concern for justice is interesting. So, and finally, respect for people's rights and dignity. This is these fundamental principles. So I think it's important to recognize that what the American Psychological Association has done here is opened up the question of how one goes about making justified decision and not simply being concerned with avoiding some sanction for violating a rule. Now, let me turn to the question of some of these provisions and their importance. Resolving ethical issues. Rule 1.04 and 1.05 distinguish informal and formal procedures and provide for a duty to report an apparent violation that has caused substantial harm or is likely to cause substantial harm. So informal procedures may only mean calling the party who you think is offended and violated the rule and trying to work out some apology, or ultimately wouldn't lead to any proceeding. But formal procedures can lead to significant consequences, and that's something that means possible dismemberment from being excluded from the membership of the American Psychological Association, and having referral of the decision to discipline or to suspend or to expel sent to various agencies of the government, licensing boards, and ultimately might impact one's livelihood, and ultimately to the possibility of a malpractice case. Although in Section 2 competence, there's an indication that, and this is in the preamble, that the breach of the duty of care is not intended as grounds for civil liability for malpractice. There's a similar provision in the lawyer's code of ethics that there's no intention that the violation of the rules should lead to a civil case or malpractice case. But suffice it to say, the breach of ethical standards, both for lawyers and psychologists, is evidence of malpractice. And ordinarily, there's a requirement in most jurisdictions, I think it's true in New Jersey, certainly in New York, an affidavit of merit must be filed by a psychologist as a condition of bringing a malpractice action against a professional psychologist. And then Section 3, Human Relationships, deals with the prohibition against torture, which I think is a pretty good definition. It says, torture is any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person or any other cruel, inhuman, or degrading behavior. So that's an important provision that basically takes a stance that was somewhat controversial with psychologists for the government condoning various forms of torture of the Guantanamo prisoners, and ultimately this became an important question, and I think the standard of the code is a good one. And of course, sexual harassment or sexual relations with a client are prohibited, and this, of course, is not news to anyone. But there's a provision that says a sexual relationship can take place for 2 years, not until 2 years after the professional relationship has ended. But even then, the psychologist has to be ready to defend their actions, even if after waiting 2 years for the end of the relationship. The duty to maintain confidence and secrets is paramount in any fiduciary relationship, and this is a close confidential relationship, a fiduciary relationship. When I testify as an expert, I always like to tell the jury that fiduciary duty is the highest duty known in the law. The duty that a mother owes to a child is no greater than the duty that the fiduciary owes to their client. So as a fiduciary, one has this high standard of care of loyalty, competence, utmost good faith. Advertising and other public statements, prohibition against false and misleading statements, and in-person solicitation is also prohibited. And that was a big issue for lawyers, this in-person solicitation. And there's a good part of the early rules of ethics were centered around these prohibition against different forms of advertising and solicitation. Now it's generally accepted that lawyers can advertise, and there's a lot of advertising going on. And I don't know to the extent that psychologists advertise, but they're limited that they can't engage in in-person solicitation as lawyers cannot. And record keeping. This is an interesting provision here. Psychologists cannot withhold records for failure to pay fees. And this is also true of the legal profession as well. And there's a prohibition against payment of referral fees for psychologists. Lawyers can pay referral fees, but only if the referral is to a civil trial specialist, someone with a particular certification in different fields of law. Education and training. Psychologists responsible for the design of education and training programs must take reasonable steps to ensure programs are designed to provide appropriate knowledge and proper experiences, and to meet the requirements for licensure, certification, or other goals for which claims are made by the program. This general description here, in light of all of the different theories that exist within the subject of psychology, one has to wonder how one can come to any conclusion as to what given theories should be or must be covered if one is going to have a minimum competence as a psychologist. So there's an open question about how far this multiplicity of theoretical materials have to be learned and used in the practice of psychology. Research, of course, is an important part of academic work, and I think it's interesting that this provision 807, deception in research is prohibited unless the psychologist has determined that use of deceptive techniques is justified by the study's significant prospective scientific education or applied value. Now, this is surprising to me, that there isn't a strict prohibition against any form of deceptive technique. In the legal, the lawyer's code of ethics, any form of deception, any form of fraud is serious wrongdoing. And then the other rule, psychologists do not deceive prospective participants about research reasonably expected to cause physical pain or severe emotional distress. So there's a limitation, really, on the extent to which deception is permitted, but nevertheless, it is an interesting point of difference between the psychology profession and the legal profession. Basis for assessment. Psychologists must have conducted an adequate examination to support statements and conclusions in their assessment, recommendations, and forensic testimony. Now, this is an interesting provision because I don't know if there's any quantification of how many or how much work has to be done in supporting statements and assessments and recommendations. Is 1 hour meeting with a psychologist a sufficient basis for rendering a report? And this is an area that I think one has to be careful. And then Section 10, therapy. There's a provision prohibiting sexual relationships with therapy clients, their relatives, and significant others, former sexual partners, and former clients for at least 2 years after termination of therapy. I think the breadth of that proposition is something that has to be recognized. So it's not only prohibition against sexual relationships with your client, but their significant others and family members and relatives, former sexual partners. So it's a very broad provision. Finally, Section 10, psychologists terminate therapy when it becomes reasonably clear that the client no longer needs the service, is not likely to benefit, or is being harmed by continued service. Now, this is a proposition that I have discussed with many of my friends who are psychologists, because it always seemed to me that one psychologist friend of mine, he was rather prideful that he had this client for 20 years, and he had a number of clients for more than 20 years. And I thought to myself, if I was trying to help somebody and I couldn't do it in 2 or 3 years, or maybe at most 5 years, I would think that I'd have a duty to pass the person on to somebody else who might take a different approach and be more effective in having come to the point where they don't further need therapy. But so it's an interesting question to me as to how that's going to be interpreted. Now, he tells me, but for his 20 years of counseling, there may have been disastrous consequences in the form of even suicide. So the question of when is someone not likely to benefit from further therapy, and whether or not there's a conflict of interest for the therapist seeking to continue getting paid for services that are unnecessary, it raises a serious ethical question. All right, so I just chose some of the provisions that I thought were particularly important rather than go through the entire document. But I would recommend that anybody who is in this field should spend some time reading the entirety of this doctrine in one sitting. It only takes a couple of hours. And one can then have that as a framework for all of their activities. So I would particularly think that having some familiarity of the general language of the code and some of the more specific standards is a must-do, and certainly should give one some comfort level that they're going ahead with a basic understanding of what the constraints are in the practice of psychology. All right, now I want to get a little bit more philosophical at this point, and I want to talk about categories of ethics and different normative theories. So there are descriptive ethics, which describe the ethical standards of individuals and groups. One could say, for instance, that you could analyze the ethics of the mafia. You could describe what standards they use for making decisions. You had to kiss both cheeks before you murder somebody, things like that, are just custom. And then metaethics concerns the study of the meaning of terms and used in ethical discourse. Finally, normative ethics concerns efforts to justify ethical standards. Now, this is really where the action is in terms of the approach to decision-making, that it's justifiable. And there are four basic categories of normative ethics. Two of them are particularly problematic. I want to discuss those. Relativism, including egoism, individual and social relativism, and consequentialist theories, act and rule utilitarianism, they're both problematic. And you can see some influence of consequentialist reasoning in some of the provisions of the code, particularly the one that allows for a degree of deception, perhaps violating a patient's rights justified on the basis of the progress of the common good, or the greatest happiness for the greatest number. So I'll talk about relativism. And well, relativism is simply the absence of any standard. Egoism says I think is right what I think is right. That's the only criteria. And individual or social relativism, what the society has as its norms, is what they think is right. That's the justification. You're following society's norms. Consequentialism has been perhaps the most favored approach to making decisions, the greatest good for the greatest number. John Finnis and John Rawls, another natural law philosopher, view act or rule utilitarianism as senseless and irrational. So I haven't got the time to go through this, but you want to explore exactly what these approaches to moral reasoning are about. Essentially, with the act utilitarianism, you judge not the act itself, but you judge the consequences that follow from the act. And similarly with rule utilitarianism, you don't follow the rule, you only follow the rule that leads to the consequences that you think are desirable. So consequentialism really ignores an act that's being contemplated and essentially moves to a consideration of what are the consequences of either violating an act or violating a rule. And that leads to a lot of confusion, and basically it's quite difficult. Finnis says that you always have to predict the future. And of course, the problem with utilitarianism is that's a theory of the good that's problematic. It's a pleasure-pain calculus. So no serious moral philosopher really supports consequentialism as a theory of ethics. Now, deontological ethics is where Kant essentially is the philosopher that we think of. Sometimes they call it deontological Kantian ethics. But it's all about rights and duties. and virtues. So those theories that promote decision-making on the basis of moral duties, acts consistent with virtues, are not necessarily predominant, but have the most support among the philosophical treatment, criticism, normative ethics. And then finally, command theory, essentially religious ethics. Morality is what God commands. And of course, we have difficulty having somebody who doesn't share your religious convictions agreeing on what God commands. So it's problematic. Now, I provided in the materials I sent you some discussion of the prominent moral psychologists that have been responsible for developing the discipline of moral psychology. It was interesting to me that moral psychology is a relatively recent development. Only the latter part of the 19th century was it recognized as a branch of psychology. And only in the latter part of the 19th century was psychology separated from philosophy as a separate subject. So the role of the moral psychologist is essentially descriptive in the sense that the development of moral theories or theories of moral development by Piaget and Kolberg and Gilligan and Jonathan Haidt that I've included here. There are lots of other theories and lots of other opinions on this question of the moral development of children and the moral standards that should be the basis for justifiable moral morality. But it's important to note here that psychology and psychologists think of themselves as essentially scientists, and a scientific approach is not necessarily going to yield the same conclusions as an approach that goes beyond science and deals with concepts of morality that's beyond really physical understandings. So I have provided you with general description of these moral theories. I was particularly interested in Jonathan Haidt because over the course of the 20th century, Jean Piaget and Lawrence Kolberg really had very profound influence on the development of theories of moral development and have been the source of philosophical treatments as well. But Jonathan Haidt writes a book that I recommend. It's entitled The Righteous Mind. What I found interesting about this, he recounts his beginning study in moral psychology and essentially comes to conclusions that I found surprising. First of all, he rejects the notion that morality is about moral reasoning. And he also rejects Kantian deontological approach to ethics and consequentialist theories. So he develops his own theory, which essentially he says morality is about, the source of morality is intuition. And he set forth 6 moral values that he said are intuitions that we follow, and ultimately that constitutes our moral stance. But what I particularly found interesting is that he adopts the Humean approach to defining rationality or reason as the slave of the passions, renders it unsuited for moral reasoning. So Haidt, in his book, and I put some quotes here, he says, "We should beware of anyone who insists that there is one true morality for all people. For all people, times, and places, particularly if that morality is founded upon a single moral foundation." And quote, "that anyone who tells you that all societies in all areas should be using one particular moral matrix, resting on one particular configuration of moral foundations, is a fundamentalist of one sort or another. His response to the problem of the world's moral diversity, is to adopt moral pluralism, which recognizes that morality differs in diverse cultures throughout the world. Haidt's moral pluralism is not moral relativism, but gets close to it. But he leaves open the possibility there are one or more cultures that have morally justified standards. So moral pluralism is not to be confused with value pluralism, which is essentially part of a number of natural law theories. So what I've concluded with here is a response to the warning that Jonathan Haidt gives. And I gave you a description of John Finnis' methodological requirements of practical reasonableness. Now, I can tell you my attraction to this view, after studying every other natural law theory carefully, including John Rawls's natural justice as fairness, a limited natural law theory that's really a political theory. Finnis's theory is an interesting blend of legal, moral, and political philosophy. And ultimately, he continues in the tradition of reason established by Aristotle and St. Thomas Aquinas. And he brings to that classical statement of natural law a new focus, a modern focus. He considers the element of subjectivity as an important part of the process of reasoning. So for Finnis, he bases his entire theory on the self-evident principles or values. And he identifies them as life, knowledge, friendship, play, beauty or aesthetic experience, religion, and practical reason. Practical reason is the means by which we achieve those particular goods or values. So this theory of Finnis is really quite comprehensive. And of course, it's subject to criticism like all theories are. One particular problem I have with Finnis's theory, among others, is that he totally discounts any role of feelings in moral decision making. And one of my other philosophers that I use in my law and morality class, Bernard Lonergan, puts a heavy emphasis upon feelings, since feelings are a response to values. So it's very interesting to me that they have a compatibility in most of their views of moral reasoning, but they differ rather radically on the question of the role of feelings. And I want to end with a proposition here that Finnis is, I think I'm close to my ending time. Finnis has set forth a robust definition of practical reason, like no other. In these principles, act according to a rational life plan. Have no arbitrary preference amongst values. You have a reason for choosing one value over another. No arbitrary preference amongst persons. You can't, there's some limited scope for self-preference and preferring your own family or friends, but it's not any excuse for selfishness or egotism. Fourth, have commitment to avoid apathy. You don't want to go through life willy-nilly. You want to commit yourself to projects and acts that promote the good in some way. Detachment, philosophical detachment, meaning don't get fanatical about your projects, but rather maintain a detached position. Limited relevance of consequences. Well, here's where Finnis confronts the inadequacy and the moral irrationality, what he considers to be irrationality of consequentialist theories, and he says efficiency within reason. So he's not opposed to cost-benefit analysis. He says it's a very important part of being rational, but it's only one principle. It's not the only principle, as it is for consequentialists. And then a very important part of these principles, respect for every value in every act. In other words, it's all about the good, achieving the good, and being concerned in every act as to what good is going to be promoted and what, if any, good is going to be impoverished or damaged or destroyed. So there's got to be a careful assessment in accordance with a justifiable choice among the goods to be promoted and chosen. Foster and favor the common good of the communities one is a part of. And here Finnis is talking about the international community should be the focus ultimately of our choice of what actions we should take. So I look at this as saying that if I have a charity budget of $100,000, I ought to give $10,000 to foreign charities dealing with poverty or hunger and other problems around the world. Peter Singer, one of the few proponents of consequentialism, Harvard, Princeton professor, he goes so far as to take responsibility for the whole world that he puts his check, he divides his check up into payments for charitable purposes around the world. Now, I don't propose that we're responsible for every action. Finnis says you're only responsible for those things that come within your life. You don't have to go out solve the problems of the world. Just deal with performing your contracts, taking care of your family, and doing all the things that you're already bound to do. So I'll leave with this Finnis's principle, his master principle. Moral is unfettered reason, undeflected by emotions and feelings, and the morally goodwill. One ought to choose and otherwise will those and only those possibilities whose willing is compatible with a will towards the fulfillment of all persons in all the basic goods toward the ideal of integral human fulfillment, happiness. So I hope that I've challenged you to take some interest in these broader questions of theory, particularly John Finnis's theory. His book is called Natural Law and Natural Rights. It's changed my life and the lives of a lot of other people because of its cogent analysis and its careful articulation of the goals, the final ends for human beings, these 7 basic goods that you can achieve by making careful choices, and then ultimately using reason with this robust definition at your disposal. So that's my conclusion, and essentially I have hopes that the psychology profession will avoid what Lawrence Kolberg feared, and that is a turn to moral relativism as its starting point for analysis of moral development. Thank you.
All right. Well, thank you so much, Professor Ambrosio. That was just a really informative talk and I think a really good review about just so many different aspects of kind of ethics and ethical considerations, both from kind of the psychology perspective and also legal perspective. And so as I'm waiting for questions to come in kind of the Q&A, I do have a question for you, and I would be very curious, kind of your thoughts, just looking at an intersection of psychology and the law. And I think this is, something that comes across my practice very often. And so, as we think about the stages of moral development and ethical justification, and as we think about, the application to psychological practice or clinical psychology, curious what your thoughts are on offering certain interventions, especially some that are more invasive, or now that we're coming up with AI-based therapies, offering those to vulnerable populations. So children, people with mental illness, people with dementia, who might not have achieved kind of that moral development, that you just mentioned, or so I would love to hear your thoughts both from the legal perspective, and kind of maybe how that maps on to just clinical decision making. Do we offer the treatment? Do we not offer the treatment? What are some things that we maybe should consider in our clinical practices to balance kind of legal and psychological ethics?
Well, Christina, I think we start with the proposition that morality is about achieving the good. And ultimately, how we live. What is the good life? Socrates posed that question at the very outset. How should we live? So the choices you make up what your life you're leading. So I would suggest to you that a psychologist really has to pretty much be a teacher of the principles that enable one to live at the highest level of self-transformation, self-transcendence. So why I think natural law theory is so helpful to anyone in the helping professions is because the very notion of the natural law theory that John Finnis represents is a doorway to everything one can. Finnis says these 7 values are everything anyone could want to do, to have, or to be. It's all about the good. And you don't have time to destroy the good if you're promoting the good. And every decision you make should be about what good am I achieving? And then the idea you achieve it through practical reasonableness. You go through a process of making a decision that says I'm acting according to a rationalized plan, meaning that my decision is harmonious, consistent with full flourishing, integral human fulfillment. I'm doing nothing to limit my life or the lives of others, but instead I'm enhancing my life and the lives of others. I'm promoting the common good. And then all of those principles really enable us to come to a sensible judgment. So I think you got to teach. That's why I never give a talk without giving some reference to the natural law theory of John Finnis, because I know what it's done for me in terms of my decision-making process. They go through a careful analysis, taking every principle into account, and ultimately understanding that morality doesn't allow itself to have precise judgments. You can't be too precise with moral judgments. There's an element of uncertainty. But you can do the best you can with the principles that are available and essentially make sure that you don't do something that's definitely wrong. So these principles are limiting principles. It says you can't do certain things. You can never rape. You can never destroy the innocent lives of babies. A lot of things once you get a sense that there are limits to your decision making, and ultimately an empowerment of the freedom of your horizons growing as you transcend the narrowness of your self-interest and you see you acting for the common good and taking joy in the flourishing of others. That's a full flourishing life. That's happiness. So the answer to the psychologist for me is yes, intervene. Go through a process of getting your clients to understand the doorway to happiness. Rollo May, who was a psychologist that pretty much adopted a natural law perspective in his practice, and I read him 50 years ago. I haven't just comes to mind now as somebody who had a point of view that I was very, very intrigued by. So psychologists, unfortunately, are schooled as scientists, and they tend to develop a philosophy of materialism and ultimately avoid more sophisticated approaches to epistemology and metaphysics. So there's a lot of room open for thinking about what a psychologist should promote and how they should lead their clients from a state of confusion and trouble to an open air of rationality controlling their decisions.
Yeah, and, definitely a lot of layers, right? And things to consider to make sure that the patient, is kind of being offered the best care possible. And so we have another question here from Dr. Ulya Erhan. You know, wondering about your thoughts about how technology has changed the value of morality itself.
Well, I think AI, and I've used AI for this talk and coming up with the prominent psychologists and their theories. Uh, and I've used AI in the course of the last 6 months, uh, and not relying upon it, but essentially providing quickly information that's relevant to my questioning or my concerns. So I think there's a danger in AI if it's not focused upon achieving positive values. Could be focused upon confusion and ultimately misused. So long as it's in the service of human fulfillment, can be a very healthy development because it gives us a chance to get a better understanding of how we deal with data. So I'm open to the progress that we can make in every field by using the technique of artificial intelligence to quickly go through possibilities and ultimately helping our evaluation of potential options to choose.
Okay, so there's another question. You might have stated this. This is from Dr. Souza. What book by John Finnis is best to start with?
Natural Law and Natural Rights. I can tell you that when I say it changed my life, I mean it, because his description of the good itself, based upon self-evident understanding, you find obvious conclusion. Who wouldn't want to have life and health and security and safety? Who wouldn't want to have beauty rather than mud on the walls? Who wouldn't want to have friendship? And the very basis that Aristotle says of the political community is friendship. True friendship, that's the model. That love is the word that connotes sexuality or whatever. Friendship is the word. True friendship, not friendships for utility, not friendships of play, which are important, but true friendship. So what Finnis does, he gives you a comprehensive approach to the good, and he asks you to rely upon self-evidence. The journey inward, you reflect upon your experience, and you ultimately come to some conclusion. What ought I seek? Those principles, first principles of natural law, follow from the first principle of natural law. The good is to be done and promoted, and its contrary evil is to be avoided. So it's all about the good and a robust understanding of the good. And he has this statement that I'm always quoting to my students, and I'll quote to you to see how problematic accepting natural law theory is, because he says, page 342 of his book, he says, there's a vast movement of thought which has sought with overwhelming historical success to expel from the analysis of individual and political action all systematic attention to the intelligibility of the goods which are realizable in action. It's all about the good. And most people dismiss the good as preference, by taste. Jonathan Haidt talks about taste. He doesn't have a grasp on the importance of objective goods. So the battleground for truth is, are there absolute values, true values, intrinsic good values that we can recognize just by reflecting on our experience, using our reason? Our reason enables us to grasp, as Aquinas said. We grasp the truth. It's not logically derived. It's ultimately something we can't argue about. It's indemonstrable. It's self-evident. Well, if self-evidence was good enough for Thomas Aquinas, probably the smartest person to have walked the face of the earth. If it wasn't Aristotle, it was Aquinas. and the clarity to which Thomas Aquinas gives us on some of these questions. For instance, Aquinas distinguishes between speculative reasoning, theoretical reasoning, and practical reasoning. Two different approaches to reason. Speculative reasoning, akin to scientific method, leads us to apodictic truth, necessary truth. That's what scientists get. They get the facts. But scientific experiments can't reveal what we ought to do. It can only tell us what is. It can't tell us why. So ultimately, you need practical reason, which starts from a very different self-evident proposition. Science starts with a proposition, something cannot be what it's not, and everything follows from that. Practical reason starts with the proposition, the good is to be done and promoted, and its contrary, evil is to be avoided. So practical reasoning, and it's with the robust definition of Finnis, gives us a wholly different perspective than what the intelligent scientists would have. And that's really where the battleground is, because scientists, Einstein accepted that God wasn't playing dice with the world. Quantum physics is now showing that the ultimate elements of reality are not matter. That waves or forces, or all kinds of open questions about what the physicists are telling us about the nature of reality. So there are a lot of things that we are not teaching our students and we are not really familiar with, which I say has to change. We need better exploration of the whole subject of morality and psychology. Need more and better understandings.
Okay.
I get a little passionate about this because I've seen the rejection. I can read Jonathan Haidt's book. So it's a very good book in terms of it gets to some point and he makes a left-hand turn, rejecting reason, accepting David Hume's notion that reason is the slave of the passions. Well, it doesn't square with my experience. It's not the slave of my passions. But this is the problem with philosophy in general, and philosophy that touches psychology is even more obtuse. But we have to look for an integration of all theory. That's what we have to look for. Some theories make no sense at all. We dismiss them, but we can't be too quick to dismiss criticism or adverse theories. We've got to try to find a way to integrate every good idea and every philosophy. Even when it's wrong in the most part, it has some truth, but they exaggerate their truth. So we have to understand that philosophies are not necessarily all the truth, but they do give us some inkling about some truth that perhaps we want to continue to explore and develop in conjunction with other truths from other theories.
And kind of to add on to that, I think your discussion today really brings up the intersection of philosophy and ethics and law and psychology, and how, there is an idealistic way that we want to go, and it's about navigating like all of the different other principles to really make sure that we're doing our job, and to make sure that we're helping the patient and doing just as much due diligence as we can for patient care. And so I really want to thank you today. We are at that 12:59, 1 o'clock mark. I really want to thank you today for talking to our group. Really appreciate it. And I think we all learned, we have a lot of takeaways and learned something new that we can apply to our clinical practice. So thank you so much. And for those of you, it was posted in the chat. We found a way to, Professor Ambrosio gave us like a collation of kind of reflections on moral psychology, and some of the deeper theory, professional ethics, inclusive of everything he talked today. But if you want that in the Word document, that is in the chat. Otherwise, thank you all for coming, and we will see you in December. And again, Professor Ambrosio, thank you so much.
Thank you for inviting me.
All right. Be well. Take care. Bye.